Beautiful people, welcome back. Immunity. There are different types of immunities against suit. The more common one you will hear is the term sovereign immunity. The term sovereign immunity is just a blanket that refers to anyone who acts as a governmental actor and their ability to be the one, based on public trust, to take care of public at large, and because of that they are afforded some form of sovereignty over the people that they're protecting. The origin of that is the 11th Amendment of the United States Constitution. It is as follows: the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States. The judicial power is mentioned in Article 3, which is Supreme Court. The Supreme Court delegated authority to reduce workload and for the purpose of having one to make final determination of the interpretation of legislature. They delegated some of that authority to the Congress, whereby the legislature now designate lower courts, whether it be municipal courts, whether they refer to it as tribunal, whether they refer to it as administrative venues, when it comes to specific matters, the specific contractual natures, landlord-tenant court, domestic court, or arbitration venues, which we went over in all these videos as to how they work. Whether they be the civil division, criminal division, all that. Each of those can be eventually moved up to the Supreme Court, which has the ultimate and really the true judicial power when it comes to the United States. Each state constitution governs what type of court in each state has constitutional judicial power. And within the United States, the Supreme Court cannot make final determination on anything if one of the United States employees are sued by citizens of another state or by citizens or subject of any foreign state. They're establishing the basic foundation that anyone who is in a position of public trust is foreign to the people. Whether people like it or not, whether people realize it or not, that's what this is saying. On top of the fact that whoever is presumed to be doing things for the benefit of public trust ought to not be held liable so long as they are within said confines. Outside of that confines, aka the Constitution, meaning they do anything unconstitutional, the moment that is done, it strips them of immunity. That being the origin of what's called sovereign immunity. What is sovereign immunity? Sovereign immunity or crown immunity is the legal doctrine. Remember, I always speak of standard test elements of doctrines. This is one of them, whereby a sovereign or state cannot commit a legal wrong and is immune from civil suit or criminal prosecution, strictly speaking, in modern texts, in its own court. You cannot sue me in my own venue. But as we've read in the 11th Amendment, it takes it further and says, even if you are foreign and you're trying to bring us into foreign court, so long as we are acting constitutional, you can't do anything to us. That's the condition. A similar stronger rule as regards to foreign court is named state immunity. Very important. Whenever you sue anyone under Fourth Amendment claims or any type of Bill of Rights and you're trying to enforce it through some type of discrimination suit, statutized as 42 USC, civil rights, state immunity will come into play, and that has its own element as to how you can move around it. But what we're going to speak of in this video is also the premise that joins with that. So sovereign immunity is a general blanket that you will hear and see when it comes to anyone purported to be an actor, a governmental actor, known as an employee of a public entity, because all governments, by foundation of the Constitution, which established and conferred these, quote, governmental entities their power, they are meant to be public. Hence, they serve the public. And part of the status quo is, since you're serving the public, you're immune from their suit, so long as you're acting constitutional. Because part of the people serving the public are also the ones in those courts. such as the acting judge. When you look at 42 USC, it basically exempts any acting judge from being sued. That's called judicial immunity, which brings us to this point. Sovereign immunity is the blanket, and under that are different types of other immunities based on the department of government you're in. Sovereign immunity is the blanket that we've just read, its origin and what it means in general. And based on what department of government you're in, that sovereign immunity is called different things, which might confuse a lot of people. When it comes to municipal police, the form in which sovereign immunity takes is called qualified immunity. When it comes to attorneys who work as a contractor with the county government, because the county is a government of its own as much as the state of so-and-so is a government, as much as the United States is a government. What attorneys do is they take that international standard lawyer number and they use it as a DBA on a county level, which issues a separate license attached to the state also. So they tie themselves into some type of immunity on that level called prosecutorial immunity, which has its own separate element. And then the acting judges working in the judicial department or acting as a public employee under the judicial department of government. Remember, there are three main departments: executive, legislative, judicial. One on the judicial level has something called judicial immunity. These are the basics that you must know when it comes to sovereign immunities, its applicability, and the fact that under that blanket called sovereign immunity, there are different elements based on where you are positioned within the capacity of a trustee for the benefit of the public. That's the underlying truth behind why it even exists in the first place. And then those are the different types, because most may not be aware of that. Most just talk about immunity, sovereign immunity, but there are different types. And those different types have their own separate elements. Sovereign immunity is the doctrine. Qualified immunity, prosecutorial immunity, judicial immunity are the different types of sovereign immunity, which has its own standard, test, and element, because each specific portion of government has its own function. And you might be thinking, well, your local municipality is not a government of its own. Sure it is. It's a body politic of its own. And most of them have charters registered in the Secretary of State because each state constitution warrants that they do so, to act as agency of the police power of the county, and that police power being the sheriff. No different than each lower court or lower trial court act as agency of the Supreme Court to reduce workload until someone makes a final determination. I hope you still keep in pace at this point, because these are very important for you to know when it comes to how the world around you works. Exposure of misunderstanding of what people think about immunity and other matters like bonds. Municipal police do not have their own individual bond. Their oath of office is the bond itself, because that's what keeps them within the bound of something called qualified immunity. The moment they act outside of that scope, they're not bonded or immune from liability. If any type of entity has any formal bond called public official bond, it would always be the mayor. And that public official bond names the beneficiary of said bond as the city or the village of so-and-so, not you, the everyday man. Because that's a private instrument to protect their affairs. But then there's a blanket bond for the entity itself, which is what you will go after. The police employee of that municipality themselves, John Doe, star number 123, badge number 123, does not have his own individual bond. There's a blanket bond by the municipality itself. And you will have to prove certain things, such as what we're about to speak of, for you to be able to even do that. If you're saying that you're going to go after a police employee's individual bond without realizing they don't have individual bond, they have blanket bonds created and established by the municipalities, which is different from the public official bond of the mayor. Two separate bonds. You would have to do a freedom of information to obtain those two, and then read the terms and conditions and see what applies to you. There would always be a clause for personal injury. Under that municipal blanket bond, there will be a clause for employee protection, theft protection, so and so. But then there will be one very small one that will mention something about personal injury. and then there will be a claim form. But we will not deviate into that because we've already done a video on that posted on Patreon, this video. What we're here to speak of is the importance of knowing the element, standard, and test of certain things. So that's the misunderstanding clarified when people say they're going to go after the individual bond of that one specific police employee. It does not exist, just so you know. And once you do start to go after it, do you know what qualified immunity is? I was having this conversation and this man or woman concluded that qualified immunity is somehow strictly based on whether you exhaust administrative remedy by first going after the bond. It's tempting to explain that you merely not going after the bond is not what creates or trigger qualified immunity. Because qualified immunity is a word of its own that has its own elements and standard that has nothing to do with you going after their bond. That has nothing to do with the bond qualifying it, but it qualifies the bond itself. Meaning your lack of going after the bond is not what creates qualified immunity. Your ability to know the standard, test, and element is what opens the door for you to go after the bond. In so many other words, you can actually sue without first going after the bond if you know what qualified immunity is. Nuance of things, subtleties of things, completely misunderstood and misplaced by people. Hence, this video for clarity, because clarity is the mother of all truth. You can have an information, but how well refined your awareness of the function of that information is what gives birth to the ability to put it to use. Other than that, it's just intellectual masturbation. Other than that, you're just hearing something from somewhere, from someone that sounds cool in the middle of a sentence, and you concluded a lot of conjecture just from someone saying one or two sentences. And then you're speaking with other people under that premise. Don't do that. Even worse, people take action on just conjectures they've heard from someone in a few sentences and make it a reality just to find out the hard way. I'm here to alleviate that issue for you. Again, immunity by any governmental actor is not triggered by lack of going through the bond claim process. Lack of making a bond claim is not what triggers any type of immunity. In fact, you can actually successfully sue without first going after the bond. Another thing is when you do go after the bond, most of them have the beneficiary listed as the entity itself, not the everyday man. Unless you can prove that they don't qualify for immunity, then the bond begins to open up. And in that case, you might even have to bring it up as a relief to be granted as part of your account to say, hey, look, go after this such and such bond because this man does not qualify for immunity. That's the proper way to do it. Not that you first need to go after the bond to remove qualified immunity. People have things twisted. Here's clarity, which is the mother of all truth. No different than your soul. How well refined the soul is determines the ability for that soul to be able to do anything, to be able to enjoy anything, to be able to enforce anything. Do your best to constantly refine your soul by refining what you know. Don't just take blind information, few sentences, and run away with it that you heard from somewhere or read from somewhere. Because in legalese, two simple words have a lot of details. Here's the clarity. Qualified immunity. The doctrine of qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights. The doctrine of qualified immunity protects government officials from liability for civil damages so far as their conduct does not violate constitutional rights. Here where it mentions statutory is referring to that public law statutized as 42 U.S.C. 1983 and sequel. Depending on what aspect of life you're in, you will realize that some civil rights claim under the 42 U.S.C. is specific to jobs. Some civil rights claim under 42 U.S.C. is specific to public accommodation. Some civil rights claim according to 42 U.S.C. is specific to unlawful arrest, which a lot of people know as conspiracy under color of law, 42 U.S.C. 1983. But there are many different specific fields of life that 42 U.S.C. deal with. Some deals with specific contractual nature and slavery, which occurs in child support and many other things. We went over that in this Patreon video. That's what the statutory portion is referring to. And that statutory portion that this is referring to can also include language of legislature on a state level, such as battery, assault, defamation, false light, intimidation, hate crime, so and so, aka tort, which can stand as their own separate cause of action outside of 42 U.S.C. Because 42 U.S.C. has a confine that limits it to race, sex, gender, color, religion, and so and so. But there are many other things that can occur without that being the motivating factor. All those other things like assault, intimidation can be that. You can have that as a separate cause of action. These details you must know. Otherwise, you're still intellectually jacking off. And all of those, quote, statutory rights must be constitutional, because even the 42 U.S.C. lets you know that it cannot be enforced unless it's tethered to a Bill of Rights, aka constitutionally secured right. We've run over that in these videos. See how everything links together. The doctrine of qualified immunity protects government officials from liability, meaning they're immune from being held accountable, against damages, meaning money. Damages with an S means monies. Damage without an S means injury. Another subtlety you must know. The doctrine of qualified immunity protects government officials from liability for civil damages so far as their conduct does not violate clearly established constitutional right of which a reasonable person would have known. That, in summary, is what qualified immunity is. If you're acting constitutional, you're covered by the blanket of immunity. If you're not, you're stripped of it. In order for qualified immunity to exist, you must know how the Constitution is violated. And another thing about immunity is, depending on the stage of the proceeding in any court case, a case can either be dismissed or prevented from being dismissed if they make qualified immunity. With discovery issues, for instance, that a lot of people don't know, where they say they deny discovery, they delay discovery. There are res judicata's, judicial interpretation of law, that says if a defendant is claiming qualified immunity, then discovery must be put on hold. Because the presumption is they're not even liable to even go through all that scrutiny in the first place until the issue of qualified immunity is resolved. And we'll go over that also. But focusing on this first, that's what qualified immunity is simplicity, because its origin is from the Constitution, 11th Amendment. And in addition to that, the only thing that confers power to any, quote, governmental actor to give them that power is, quote unquote, government, upon the consent of the one that's governed. It's the Constitution. Therefore, they have to abide by it in order to have immunity. Very simple. It goes on to say, once the defense of qualified immunity has been raised, meaning it has to be evoked, quote, the onus, meaning the responsibility, is on the plaintiff, you, to demonstrate, 1, that the official violated a statutory or constitutional right, and 2, that the right was clearly established at the time of the challenged conduct. This is the necessity of you articulating that you are in fact exercising a constitutionally secured right. Sometimes that's all it takes for you to evoke lack of qualified immunity, to articulate the fact that you are exercising a constitutionally secured right. You are shifting burden of proof by simply evoking those things verbally or on a piece of paper. Ever too often would you find people trying to be so complex with many different words and many different things, and they don't deal with the core of it. It's like they're tiptoeing around saying, hey, this is a constitutionally secure right, which is the main thing they have to say in order to shift burden of proof, in order to prove that they don't have qualified immunity, because it's one of the two elements that you have in order to strip it away from them. Remember, the element of qualified immunity is that so long as they're acting constitutional, which is an undisputable law that everyone is bound by, if they're acting in accordance to it, then they're qualified to be immune. And because of that, it is on you to show that they violated it and that it was clearly established. One of the easiest ways to make it very clear that any instance you're involved in has a constitutional secure right clearly established is for you to articulate it. But then, of course, you would have to know the fact that what you're articulating actually applies to what you're enforcing or preserving. Quote, to be clearly established, a legal principle must have a sufficiently clear foundation and then exist in precedent, such that it is settled law, meaning the right itself that you're enforcing is clear and concise. You have a piece of camera, you take a picture of a flower. That's speech. Someone got upset and say, I'm gonna call the police. I'm gonna call my superhero. If you don't know that that picture is synonymous with speech, which is settled as law, and we went over this fact in these videos, if you flip someone off or use a language that is profanity, and it puts someone off and they start to enforce their personal feelings and they want to compel you to feel the way they feel and suffer just because they feel somehow, because you flipped them off or used a language that offended them, know that that's a constitutionally secured right so long as it's not for the purpose of fisticuffs or disorderly conduct. If someone comes and just arbitrarily demand an ID and there's no reasonable expectation that a crime has committed, is being committed, or is anticipated, and the totality of circumstance shows that you are involved in it, then Fourth Amendment, which is a settled law because it's undisputable, is the foundation to how they even have their power. And they even take an oath to it. Hence it's a settled. Hence it's undisputable. Know that they're violating that Fourth Amendment, and so on and so forth, based on a standard test on element of each of those constitutionally secured rights. So you have to know what you're talking about if you want to say you're exercising a constitutionally secured right. The Supreme Court has not yet decided what precedents other than its own qualify as controlling authority for purposes of qualified immunity. Meaning outside of res judicata, qualified immunity is not really succinctly defined. Every now and then you see vague reference to qualified immunity, which comes in forms of statute of limitation. Qualified immunity comes in form of statute of limitation, where they say after this certain amount of time, you can't sue us anymore. That's a hint or a mild form of qualified immunity because you're barred from suing them. You're barred from holding them liable. For instance, with Federal Tort Claims Act, when it comes to the United States, say USPS, for example, you have 2 years from the date of the damage, according to Federal Tort Claim Act and 39 CFR, to actually first file something called SF-25, which is a notice of claim privately. And then whether it's denied or not, you have up to 6 months after that to then bring a public suit. Those statutes of limitation and those increments, it's called qualified immunity. So qualified immunity also comes in form of statute of limitation. But beyond those little subtle hints of it, the clearly established language of qualified immunity is determined by the ultimate judicial power of the United States, called the Supreme Court. Because they have not yet decided what precedent other than its own, meaning other than what they've mentioned in res judicata, such as what was previously mentioned. The 10th Circuit, however, has stated that, quote, ordinarily, the standard requires either that there is a Supreme Court or 10th Circuit decision on point, or that the, quote, clearly established weight of authority from the courts has found the law to be as the plaintiff maintains. Meaning now you must know these standard tests and elements behind these doctrines that we're going over. The interpretation of legislature called res judicata. Again, you don't have to riddle your pages with citations, because for each citation of any type of res judicata, there's about 500 or more case law that contradicts that. And then the specific citation has to be specific to your circumstance also. It has to be similar. Just because it uses similar verbiage or similar rights does not mean the circumstance that led up to that decision applies to you which when you cite it, they'll be looking at and doing research on. So you don't want to look stupid unless you know a lot more of the case laws that relates to that and the specificity that cause them to come to that conclusion within that specific case law. So it's best that you just know the principles of how it works and simply implement that into your circumstance. A lot of people have this misconception that they have to cite case laws in their documents to be smart or to actually have validity as to what you're saying. You're just still lying to yourself about how this thing works. Don't be delusional. The 10th Circuit has explained the, quote, clearly established prong, meaning this is how you qualify for it as a standard, of the qualified immunity analysis as follows. A clearly established right is one that is sufficiently clear that every reasonable official would have understood that what he is doing violates the right. Hence, you articulate it. You bring it to his awareness, aka mens rea. That way he knows, which triggers duty, and lack of that duty triggers negligence. And by way of that negligence, he knows that he ought to have done better because he swore oath to it and you reaffirmed it verbally through your act and your words. Not by asking them, did you swear an oath, but by knowing the standard test and element of each right that you enforce is specific to your circumstance, and then articulating the fact that you are exercising said right. At that point, you shifted the burden of proof on them. And of course, always record the interaction, preferably audio, but video is good too, but you run the risk of them deleting it. But audio can be more covert. A clearly established right is one that is sufficiently clear that every reasonable official would have understood that what he is doing violates the right. Although plaintiffs can overcome a qualified immunity defense without a favorable case directly on point, meaning you don't even have to be on point. You just have to know what your substantive rights are, because you are the ones that's governed. And as we've read in the past, your consent is required. But you cannot waive consent or give consent or deny consent if you don't know what your substantive rights are. And those substantive rights are preserved by the Constitution, which established the power that governments have. Although plaintiffs can overcome a qualified immunity defense without a favorable case directly in point, existing precedent, res judicata, must have placed the statutory or constitutional question beyond debate, meaning it's undisputable material fact. The dispositive question, meaning anytime you see this term dispositive in any case law, in any res judicata, it either refers to anything such as summary judgment or motion to dismiss, which would get rid of the case. The dispositive question is whether the violative nature of the particular conduct is clearly established. The huge part of the clear establishment of whether the right exists or not is the extent and limitation of how well refined you are with the awareness of what you say your rights are. Simple as that. But they're not going to tell you that. Therefore, they put ... Meaning there are things in between that we're not saying. But we're moving on. Qualified immunity protects all, but the plainly incompetent or those who knowingly violate the law. We've mentioned how you can trigger that. The Supreme Court has repeatedly stressed that courts must not define clearly established law as a high level of generality, since doing so avoids the crucial question whether the official acted responsibly in the particular circumstances that he or she faced. Meaning the standard to determine whether qualified immunity is waived is quite low. No different than probable cause being a very low standard of evidence for them to say you did something, because it's just a probability. The specificity, quote unquote, of the rule is especially important in the Fourth Amendment context. Courts have, quote, discretion in deciding which of the two prongs of the qualified immunity analysis, what are the two prongs? That the official violated a statutory or constitutional right, and that the right was clearly established at the time of the challenged conduct. Courts have, quote, discretion in deciding which of the two prongs of the qualified immunity analysis, should be addressed first in light of the circumstances in the particular case at hand. In light of the circumstances, your circumstance, in the particular case at hand, your case. See what I mean by you citing a bunch of case laws really makes no difference if you don't know how they specifically apply to your circumstance? Don't get lost in the sauce thinking citing case laws make you smart, or it's going to be impressive, or it's going to increase your likelihood of succeeding. Don't lie to yourself. Be honest with yourself. If you want freedom, you have to be truthful. Because the people who are abrogating your freedom do it by all means possible. If that means shoving truth underneath, they'll do that. In that case, two wrongs don't make it right. In order for you to bring what is shoved underneath, which is truth, in order for you to bring it out, you must first have the capability to wield it. Because what you're reaching underneath that's been shoved down is truth itself. Therefore, you have to be truthful to yourself about how these things work, for it to work for you. Courts have, quote, discretion in deciding which of the two prongs of the qualified immunity analysis should be addressed first in light of the circumstance in the particular case at hand. In Pearson, the Supreme Court recognized that, quote, when qualified immunity is asserted at the pleading stage, the precise factual basis for plaintiff's claim or claims may be heard to identify, and thus the determination of the first prong of the qualified immunity analysis may be, quote, an uncomfortable exercise. Quote, the answer to whether there was a violation may depend on the kaleidoscope of fact not yet fully developed. Remember I told you earlier, depending on what you're doing, depending on the stage, pleading stage, such as discovery, if they bring up qualified immunity, they bar discovery. That's another trick that they do behind closed doors that most people don't know, and they complain, oh, they didn't accomplish discovery. I sent it to them. They didn't follow the rules. But do you know the loopholes that's silent, that's going on, that I'm sure they put on paper, but you didn't see it. You read it. You read it in black and white, but you don't know how it correlates to other things that they are invoking as a bar to discovery process that you're trying to go through. One of them is qualified immunity. You have to know these things if you say you have rights. The Supreme Court recognized that when qualified immunity is asserted at the pleading stage, the precise factual basis for the plaintiff's claim or claims may be heard to identify, and thus the determination of the first prong of the qualified immunity analysis may be an uncomfortable exercise. Meaning, if they invoke qualified immunity at a certain stage of the case, it will be uncomfortable for them to proceed unless they first identify that they don't have it or have it. Then they proceed, because if they do have qualified immunity, then there's no need to start doing discovery. And part of the excuses, they will say they want to save judicial economy, to save money and time. You have to know these loopholes, or else they will put it on paper in black and white. They might not use this exact verbiage, but it will function based on the principles of it, aka the details, aka the kaleidoscope of it. If you don't see it, if you don't have the scope deals with perspective. If you don't have the perspective in your mind, and you're just so limited to, I want to do discovery, they're fraud, they're not answering it, they're not following the rules, but you don't see all the other details, the kaleidoscope involved, you're just lost in the sauce. And it's not their obligation to tell you, look, there are other details that's involved in this beyond what you're saying. Again, you have to know this. The Supreme Court recognized that, quote, when qualified immunity is asserted at the pleading stage, the precise factual basis for plaintiff claims may be heard to identify whether qualified immunity exists if the opposing opponent claims it. And thus the determination of the first prong of qualified immunity analysis may be an uncomfortable exercise, because the answer to whether there was a violation may depend on the kaleidoscope of fact not yet fully developed. Another trick to this is you can also flip it, because it's a double-edged sword, and use it to your benefit. Meaning, you can say, I'm demanding discovery to really come to the bottom of this thing to determine whether they have qualified immunity or not. This is why you have to use your mind. This is why the information you know have to be refined. No different than the quality of someone's soul and the activity they engage in. The information you know have to be refined. It can be used both ways. That's why Lady Justice looks like this. See that thing she's carrying? It's a double-edged sword. It falls both ways. Anybody can get it. So long as you know how it works. Don't many spiritual texts conform to modern time as religious texts? Don't they say, let your words be your sword? These are the words that you can swing both ways as a sword. You must know it. The Supreme Court further acknowledged that in certain cases, meaning they're being very specific to the circumstance of the case, which you must know. The Supreme Court further acknowledged that in certain cases, quote, a court will rather quickly and easily decide that there was no violation of clearly established law before turning to the more difficult question, whether the relevant fact makes out constitutional question at all. There's this thing called constitutional question when it comes to evoking federal jurisdiction, meaning there's a damage that occurred and there's a question of whether the Constitution has been violated or not. And they're saying if qualified immunity is invoked by the one you're suing, they are quick to first decide whether there was a violation or not before they even say, was the Constitution involved? It might seem backwards to you, but in truth it's actually not. What they in summary just said here, as convoluted as it might sound, is that you have to know what is specific to your circumstance and how they violated it. Or else they would ride on the horse of qualified immunity, laugh at you, and make you a scapegoat. Simply because you've yet to refine your awareness of what one thing is or the other. Which goes back to misunderstanding that lack of going after their bond is what triggers their qualified immunity. It is not. What triggers qualified immunity is the extent and the refinement of how you know whether they violated the Constitution or not. Not whether you go after the bond. Now let's go into the deeper details of how they use qualified immunity to bar discovery. Let me show you something. A little tool, a little secret, a little powerful tool on a toolbox of attorneys that they use against people. Silently, you will put all the paper, demand discovery, rule this, rule that. Yeah, you think you're doing something, which is good. And they know you are doing something. But they know you don't know how that something you're doing can be silently prevented from working. Have you ever had a shard of glass stuck underneath your foot before? However big you are, however muscular you are, however strong you are, you try to add force and sprint like you normally would, or just casually walk in your shoes or barefooted around your home, around wherever you are, with a shard of glass underneath your foot. As small as that is, it will put a dent into your whole emotional state, your whole physical state. It would affect the way you work, it would affect the way you walk, it would affect the way you talk, it would affect the way you feel. That's what they do with qualified immunity and the natural process of things called procedural due process, such as discovery processes. Let me show you how they use qualified immunity to bar things like summary judgment, which when you bring a claim and you know you're on point, you don't even have to go through a discovery or trial. You can just do a summary judgment and the judgment will be made in your favor if you know how to do special proceeding, which a lot of people don't also know. They say they want to sue, okay, you get judgment. The reason why they say 99% of judgment don't get collected is because people don't know how to collect it. People don't know now you have to sue a thing in rem suit to actually collect or attach other things that we've went over on Patreon and we'll keep going over in further details. So things like summary judgment that you could use to basically throw a slam dunk, or things like discovery to basically dig deeper into the case and expose them or other moves that you can do that will be detriment to them. This is how they use qualified immunity to hinder those. To put a little sharp shard of glass underneath the foot of that mechanism that you built and you're trying to put into motion, that you're trying to bring into life. In Section 1983 action for unlawful conduct by sheriff's deputies, defendants move, oh, by the way, this is the United States District Court, Northern District of California, case number C20-04679WH8. The first case we went over is in the United States District Court for the District Court of Colorado, case number 1:21-CV-02010. In this Section 1983 action for unlawful conduct by sheriff's deputies, defendants move for summary judgment on all claims. Plaintiffs have moved for summary judgment on the lawfulness of the search and seizure, meaning they both move for summary judgment to say, look, what I'm saying is undisputable. They're both saying that. Therefore, just close this thing out. Dispose of it in my favor. So now it's a tug of war. The plaintiff did a summary judgment to say, look, my complaint is flawless. It's undisputable, because that's one of the requirements of summary judgment. The defendant is saying, look, I did a motion to dismiss, and it's undisputable that this case is trash. Throw it out. Do a summary judgment for me. A dispositive motion on both ends. A counter and cross motion. A cross motion. Now let's look at how qualified immunity is tied to the move people can make to basically slam dunk cases. To prevail at summary judgment on claims of discrimination, defendants must show that the undisputed facts revealed deputies did not intentionally, quote, act in a discriminatory manner. Meaning whatever you're saying, if you're the defendant, it has to be undisputable. If you're the plaintiff, it has to be undisputable. That's the core of summary judgment. Meaning you're not speculating. And the way it's undisputable is if it's a criminal matter, it has to be beyond reasonable doubt. If it's a civil matter, it has to be by preponderance of evidence. A. Seizure. Defendants contend that the detention was lawful. Of course, they will. Even if they know they're wrong, they're still gonna fight back. You know, people have this thing in their mind whereby they know everything they're doing is right, and they know that everything the opponent is doing is wrong. Thereby, they think if they just sue, they're just gonna concede and say, oh, you got us. Of course not. And then people get upset when they don't give up. What do you think they're gonna do? Just because you sue them, you think they're just gonna say, oh, you got us? Even if they know they're wrong, they're still going to stand on that, which now warrants you to know what's going on with your preserved rights in your circumstance. Competence is something you can never run away from. You are here on this earth to refine your soul through knowledge and learning and growing. You cannot run away from that. Even these man-made laws hold you against it. Human nature holds you against it. Have you looked around recently or in the past and saw that people who usually do things that are not necessarily good for other humans are often the most confident ones? Right. That's nature's law telling you if you know you're doing what's right, you better stand up and speak up. But you can only properly do that if you are competent. Defendants contend that the detention was lawful. They seized someone against the Constitution, and here they are saying, we did the right thing. These days, this tends to be what happens. What is clearly wrong will be verbalized and expressed as though it is right, to the point where it might even convince you. So much that you're thinking, are they serious? Do they really believe what they are saying? Of course they do. Someone who wants to take advantage of you has to first convince themselves that they are right, even if it is clear that they are wrong, which always brings the responsibility back to you. Defendants contend that the detention was lawful, pursuant to their reasonable suspicion that plaintiff might be auto burglary suspect. So now you have to know what reasonable suspicion means. The fact that reasonable suspicion exists in this verbiage is referring to something called Terry stop, which we've run over in about 4 or 5 different videos. Reasonable suspicion is the loophole to probable cause that people focus on. People focus on probable cause but fail to realize Reasonable suspicion is what they use to qualify that. And 9 out of 10 interactions, based on the 3 types of tiers of interaction, which we go over in Patreon. So there are 3 tiers of interaction when it comes to municipal police and everyday men. Based on those 3 tiers of interaction, most of them are not looking at the 3rd one, which is probable cause. They're looking at the first 2. One of those first 2 being reasonable suspicion, because that's the loophole to probable cause. Pursuant to their reasonable suspicion that plaintiff might be auto burglary suspect, and separately for possible violations of the vehicle code, an officer may conduct a brief investigatory stop, also called Terry stop, quote unquote, where the officer has a, quote, reasonable articulable suspicion that criminal activity is afoot. The order denies summary judgment on both liability and qualified immunity grounds. In other words, they're trying to say, look, we're moving to summary judgment because we're immune. If they can do this for dispositive motions like summary judgment or through summary judgment, they can do the same thing to bar discovery. They say, look, we are immune from this. But remember that double-edged sword? If you know how to finagle your circumstance and say, look, this and that happened, and we have to dig into it further to qualify their immunity, you can use it that way. This order denies summary judgment on both liability and qualified immunity grounds because counsel for the defense made 4 material misrepresentation at the hearing. We know they were material because counsel himself brought them up. Thankfully, plaintiff's counsel was prepared and exposed all 4. So now they go through the underhanded tactics that attorneys do, blatantly in your face. They will lie to you and look at you in the eye. They will misrepresent facts and look at you in the eye. You have to be able to identify them. They will shove the truth underneath the rug. And while they're shoving the truth underneath the rug, they will say, what you're saying is trash. And in saying what you're saying is trash, they will try to bar anything you're trying to do, like discovery or summary judgment, by saying, we're immune from it. You have to know what qualified immunity is and how they will use it. You're expecting something longer, aren't you? When it comes to how they use qualified immunity to bar whatever it is you're trying to do, like discovery or summary judgment. It's really simple. They will just assert the claim. Because according to that first res judicata, they know that all they have to do is just assert qualified immunity. And then it triggers a 2-prong for you to know what you're talking about. If you don't know what you're speaking of when it comes to the standards, an element of qualified immunity, and when it comes to the details of what you say your rights are, then they will just use that blanket of immunity and throw it at everything and anything. You must know this. You still want some more? When it comes to the fact that this thing called qualified immunity is one of the tools that's functionally used to stop discovery or dispositive motions or any other things you're trying to do. Case number 1:12-CV-01662. District courts have extremely broad discretion to control discovery. That's a starting point. Besides those basic things we've read, they will merge it with the fact that they can control discovery however they want. In accordance with federal rules, a court may, quote, for good cause, limit the scope of discovery or control its sequence to, quote, protect the party or person from annoyance, embarrassment, oppression, or undue burden or expense. Remember, I mentioned this as one of the reasons, judicial economy. Exactly. And the annoyance and embarrassment or oppression or undue burden is the fact that, look, if we're saying we're immune and there's a chance that we're immune from this, then there's no need for us to even go through the process of discovery of showing you things you're not supposed to know in the first place, because we're not even supposed to be sued because we're immune. These are the underlying principles that are used against people. When people complain, they're not under discovery, I've done this, I've done that. Do you know these principles before you start to whine about it? Now, here's what slightly favors you. The mere filing of a motion to dismiss does not automatically state discovery. A motion to dismiss, as mentioned in these videos, Motion to dismiss is all it takes to kill the sufficiency of any bill you bring at equity or any complaint you bring at law. Anything you're saying they're doing that you're pointing fingers at, all it takes to kill all of that is a tool called a motion to dismiss. And within that motion to dismiss, they can invoke qualified immunity. And through that, they can create a chain effect of delaying everything that you're attempting to do. You must know this. The mere filing of a motion to dismiss does not automatically stay discovery. Sounds good to your favor, right? Right. But notice at the beginning it says, look, district court has broad, not just ordinarily broad, extremely broad discretion to control discovery. Meaning those rules governing discovery are meant to be broken, is what they're telling you here. The mere filing of a motion to dismiss does not automatically stay discovery, nor does filing a motion to stay means that a court will automatically grant it. While stay is just another legal term to say put something on hold. It's a no-brainer, stay. While stays are granted with some frequency, in some cases, the existence of a dispositive motion are things like summary judgment or motion to dismiss. So you keep seeing this term dispositive motion. That's what it means. Let's just read it in a little bit of details, and then we'll go back to what we were saying when it comes to how qualified immunity is used to stop what you're trying to do. What does dispositive motion mean? Because you've heard me repeat it in this video, many other videos so often, and you will keep seeing it in these documents. In law, a dispositive motion is a motion seeking a trial court order entirely disposing of all or part of the claims in favor of the moving party without need for further trial court proceeding. That's what motion to dismiss does. That's what summary judgment does. Summary judgment and motion to dismiss are asking something to be done without even going to trial. Dismiss this case without going to trial. That's called motion to dismiss. Look, award me this and determine this without going to trial. It's called summary judgment, so long as the facts are indisputable. Quote unquote, to dispose of a claim means to decide the claim in favor of one or another party, as a lawsuit may comprise numerous claims made by and against numerous parties. Not every dispositive motion seeks to dispose of the entire lawsuit. This is the reason why I always say have different counts. That way, if a dispositive motion catches one of the different weaknesses in one count, the other survives. And that way your entire suit is not dead. Most people fail to put different counts in their suit. Therefore, once one thing is attacked, it creates a dominoes effect that kills the rest. And then they begin to complain, oh, they dismissed the entire case. Of course they did, because you didn't know how to structure the details so that if they attack one thing, the rest stands. It's called counts. A lawsuit may comprise numerous claims made by and against numerous parties. Not every dispositive motion seeks to dispose of the entire lawsuit. In the U.S., the most common type of dispositive motion seeking to dispose of the entire lawsuit are those for summary judgment. In other words, they're letting you know summary judgment is a type of dispositive motion. Many U.S. state jurisdictions will provide for a partial summary judgment or motion for summary adjudication of issues, which only seeks to dispose of part of the lawsuit. Then goes on to say the two principal type of dispositive motion in contemporary, meaning modern American legal practice, are the motion to dismiss, sometimes referred to as demurrer in the minority of U.S. state jurisdiction, and the motion for summary judgment. Now that we have that out of the way, so it doesn't sound as though I'm just making things up when I say dispositive motions, a motion to dismiss and summary judgment, well, there it is. Now let's go back to how qualified immunity is used to delay discovery and anything else you want to do, such as to dispose their case without going to trial. So, while stays, meaning a hold onto something, are granted with some frequency, meaning they will do a motion to dismiss, aka dispositive motion, and evoke qualified immunity. And because they evoke qualified immunity within the motion to dismiss, they're going to say, you know what? There's an underlying thing that now triggers that says, don't worry about discovery. Let's see if this entire case can be disposed, because they say they're not even supposed to be liable to any of that anyway. So we're just going to stay discovery, aka put discovery on hold. While stay are granted with some frequency, in most cases, the existence of a dispositive motion is not the sole, it's not the only reason for granting the stay. Instead, a stay of discovery is generally appropriate only when a party raises a potential dispositive threshold, meaning three things are required, meaning one of three things are required. Hence, threshold. The thresh part is 3. The hold part, meaning 3 and 1. Instead, a stay in discovery is generally appropriate only when a party raises a potentially dispositive threshold, meaning it only has to just be a potential. It doesn't even have to be factual. They just have to raise it. They might not qualify for immunity, but so long as they raise it, they can use that to delay discovery. Instead, a stay of discovery is generally appropriate. A hold on discovery is generally appropriate only when the party raises potentially dispositive threshold issues such as a challenge to a plaintiff standing or pending resolution of qualified immunity claims. A stay of discovery is generally appropriate only when a party raises a potentially dispositive threshold issues such as pending resolution of qualified immunity claims. See the loopholes? They will put discovery onto hold because they know the acting judges have extreme broad discretion to control it. And there's a very low standard for them to hold on to discovery as a tactic, which is to just potentially evoke qualified immunity through a dispositive motion called motion to dismiss, which is all that is needed to kill the complaint that you brought. Do you see the game? The basic thrust of the qualified immunity doctrine is to free officials from the concerns of litigation, including avoidance of disruptive discovery, quote unquote. See that? These are the loopholes that they use. A lot of people know discovery is important. Do discovery, do that. Oh yeah, once you ask for it, they can't do anything else because now you got them. Now they have to produce it or else they can't do anything. But they have something for you. Silently, they would evoke this and you would not know because all this foundation are missing in people's minds and they will not disclose these to you. And in fact, they'll even cite these same case laws, but you would not know the summary of it because each case has about 80, 60, 100, 200 different documents. Now you have to fine tune what part of that docket within a specific document. Even if you find one document, it might be about 6 or 7 or 30 pages long for you to know exactly why that citation is significant. And a different way they can cite things to the point where they can make it convoluted, even if you know how to read citations. All that is being compiled here to show you silent things and silent tactics that's used to hold on to things, to delay things, to prevent people's enforcement of certain things. You must know this. And the way to prevent that from happening is for you to know the two prong of that doctrine called qualified immunity. And then prove those two prongs to your favor. And all this becomes insignificant. But this is one of the tools they use. Until next time, we'll speak of prosecutorial immunity and judicial immunity and other types of immunity. Take care. Best of luck.